So what's the problem with just passing everything via beneficiary designation? Hi, my name is Claire Langton-Yanowitz, where we help families with wills, trusts, and probate. And today I'm going to talk to you about potential pitfalls to passing all your property via beneficiary designation. So I've met with a number of clients throughout the years who have said, aha, I found a loophole. I'll just list a beneficiary on all my accounts. I'll put a transfer on death deed on my home, and then I don't need a will and trust, right? And my response is potentially, but let me tell you about different pitfalls to having a plan like that. Pitfall number one, when people will set up their accounts and homes so that everything has a beneficiary, I ask, how many beneficiaries do you want to inherit your property? If somebody has a number of kids, they're going to all get the property equally, and there are going to be some final debts that are going to need to be paid. So when people die, oftentimes there's some final medical bills, there's oftentimes funeral bills, you oftentimes have to file someone's final tax returns. And so those people that inherit your money are going to have to work together to pay your final expenses. Now, if one or more of those people have money problems, they have creditors after them, maybe they're getting divorced, and there may be a spendthrift, they spend all the money at the minute they get it, that might create a burden on the other beneficiaries. Maybe you have 3 kids, one has the creditor issues, and so as soon as that money hits that kid's bank account, it's gone. And that leaves you with your other 2 children having to pay unfairly for all your debts. Whereas if you had a will or you had a trust, you would have someone in charge of paying all your final debts. And only once those are paid would the money get distributed out to the 3 kids. So basically, the expenses would be paid first before the distribution is made. Now, some people will be in a situation where they want to list minors as beneficiaries. And that's never a good idea, because when you list, minors can't inherit directly. They need to inherit in a trust or in a Uniform Transfer to Minors Act. They can't inherit directly. So if you list your grandchild or your child who's a minor as the beneficiary on your IRA, your bank account, anything, there is going to be a whole process to getting that when you die. The account might be frozen until they're 18. We might have to go through a conservatorship to get someone appointed to take over that money and account to the court on how it's spent down to the penny until the child reaches 18. It's not a good route to go. So whenever we have minor beneficiaries involved, I never want to pass things to them directly via beneficiary designation. Now, another problem with this type of planning is if people die in the wrong order. So if the beneficiary dies before you do and you don't update the beneficiary designation, there's an uncertainty on where those assets are going to pass. Okay, so let me give you an example. Let's say you have 3 kids and kid 1 dies before you do. There is a plan document with the account that is probably going to dictate on how the deceased kid's share is going to pass. And it's probably going to pass in one of these ways. First, their share may pass to the other beneficiaries. It may drop to the contingent beneficiary. It may drop to that child's will or trust, or if they don't have one, through the default rules in the state that they live in. It could also pass to your estate and trigger probate. So basically, if you list things via beneficiary designations and then people die in the wrong order, you have this uncertainty on who's going to inherit your property. Also, it can be extremely beneficial to have some beneficiaries not inherit outright, but to inherit in a trust, because that trust can act as asset protection in the event the beneficiary is sued, goes bankrupt, gets a divorce. It can also be helpful that disabled beneficiaries inherit in a trust, that people with chemical dependency inherits in a trust, and if a married couple has over $3 million, that's the Minnesota estate tax exemption. If a married couple has over $3 million, we don't want to simply pass everything directly to the surviving spouse through joint ownership or beneficiary designation. Because if you do that, you only get one Minnesota estate tax exemption. And so while you might save on not going through probate because everything passes through beneficiary designation, you may save on not having a will and a trust. I can tell you that you are going to be in a bad situation for estate taxes. And most of the time, the cost to get that will or trust is only a small fraction of what you're going to save in estate taxes. So it's much better to have a plan in place that doesn't pass things directly to your surviving spouse if you're over $3 million, that instead it's set up to go to a trust for the surviving spouse's benefit so that you can preserve the first spouse's to die estate tax exemption. Thanks so much for your attention today. If you have any questions, feel free to reach out to our team. We would love to help you. Thank you.